Hi, my name's Jane Scarf, and I'm coming to you from Ottawa, Ontario, Canada. And today I want to talk to you about sovereignty and the Canadian Bill of Rights and what, relationship a sovereign has with the Canadian Bill of Rights. And can they use it without losing their sovereignty or compromising or anything or accepting any jurisdiction or paying tax or anything? Can they still use it? I want to start off by stating that right out of the gate, the Canadian Bill of Rights makes this statement. It's an act for the recognition and protection of human rights and freedom and fundamental freedoms. So what that's saying is that the government is not giving you these rights. They're recognizing that you already have these rights, and they're committing to protect them. And there's other, just a sec now here. I want to read you. Okay. I can't find the reference to what I was going to read to you, but it uses the term, oh, here it is. Okay, so in the preamble, so this is the second sentence, so right out of the gate. So one, they're recognizing your rights and committing to protect them. So what do we have to do? What does the citizen have to do to get this this protection and this recognition of the rights? The next sentence says, the Parliament of Canada affirming that the Canadian nation is founded upon principles that acknowledge the supremacy of God, the dignity and worth of the human person, and the position of the family in society of free men and free institutions. Further affirming also that men and institutions remain free only when freedom is founded upon respect for moral and spiritual values and the rule of law. And being desirous of enshrining these principles and the human rights and freedoms derived thereof in a Bill of Rights, which shall reflect the respect of Parliament for its constitutional authority, and which shall ensure the protection of these rights and freedoms in Canada. And then it says, therefore, Her Majesty, by and with the advice and consent of the Senate and the House of Commons of Canada, enact as follows. And then they go on to outline your rights. Now, there's a couple of things here. Human person. They're dealing with human persons. And that description about what that act is, there's no responsibility, there's no undertaking on part of the person who it applies to. It applies to human persons. And it's all the responsibility for enacting this is fully on the government, on the Crown, and including the government. So it's an act of recognition and protection. So they have to put things in place to make sure that you have these rights supported. So it's my contention that if you are autonomous or independent, you have the same rights. Like from walking around the ground in this country as a human being, they have to recognize and protect those human rights. You don't have to accept authority of the court or the jurisdiction of the court or pay taxes or anything else. Now, I'm not advocating any of this. These are, choices that each individual makes. I personally think that we're born autonomous and we're sovereign, and unless we expressly state that we are putting ourselves under the jurisdictions that are involved in the whole state process, we're not obliged. We don't have to have done it formally if we just accept it. I mean, that's cool. That's good to go. But if you never consented and you don't agree, then you're not obligated. And personally, my position is that this is my country, and these are the processes that we have and our ancestors have created to help assist the functioning of the society, organization and function of society. And we have lots of lumps and bumps, and we have corruption where officials or official systems are not acting as though they should. Now, to me, you know, somebody can say, and I'm not going to argue with them, like, that's it, this system, I can't handle it, can't be reformed, I'm out of here. But I'm not taking that position. I am taking the position that I'm sovereign and autonomous, but I want to put my energy and my will and desire into having a system that does support the interests of the people that are living in that system. And it is up to us. And this idea that they did all this to us and they took our rights and they, no, we're part of that. We let them, and we're continuing to let them. And the violations that are currently going on with all this COVID stuff, it isn't even legal. And we're letting them and complaining as though we have no power, we have no rights, we have no way to deal with this. And so many people are saying, oh, you know, it's already a communist country, Canada, there it is, all our police are fascist, our government's fascist. No, it's not. That's not true. We need to fix things, and we need to fix things, quite a bit of things. You know, I'm not saying, we have no problem, this system's working fine. No, it's not working fine, but it's not their fault. It's our fault, including them. And I want to get it back on track, and it doesn't require very much, if any, legal changes. We already have all the protection, our privacy protection, a right to informed consent, a right to be treated equally by the law and to be protected equally by the law. That's already there. And all the case law to support it is there. It's all predicated by common law precedent. And that makes it all the stronger. Like the Bill of Rights, I'll just go through the main criticisms of it, and I can address each one. One is, oh, that old thing, that was superseded by the Charter. Well, no, it wasn't. Because first of all, the Charter is not law because it has no royal assent. Quebec didn't sign on. It didn't become part of the repatriated Constitution that we got in 1982. The Constitution itself was repatriated, like, as I understand now, I didn't at the time, but I understand now that 1931, the Statute of Westminster was passed, which gave Canada its status as its own country, as an independent country, and it broke us from responsibility to adhere to the British North American Act. So we should have, at that time, went forward and created a new constitution, but we didn't do that. We just kept using the same one. And really, it was not lawful, like from 31 till 82. But in 82, they took pretty much the same legislation. I think there was a few amendments even, and the name was amended, and they repatriated it. They put it through the process of Parliament, and it became a law in Parliament with royal assent. But they tried to bring the Charter in there, and that didn't work. The Quebec didn't agree to it, so it never got, it's not part of it. If you look up the documents for the 1982 constitutional repatriation, the Charter is not in there. And I'm glad it's not in there because it's, in my view, it's a document that was created to try and assist incoming communism. Because what communism is a political state in which the people have no rights. All the power rests with the government. And anything the government wants to do, the government can do. It doesn't have to, figure out if it's fair or if you have a right to something or that's not of any interest to a communist country. They do whatever they want. And that includes Your right to life, you don't even have the right to life. Liberty, security of person, not a concern. Not a concern at all. And protest rights, I don't think so. You cannot say anything they don't want you to say in that state. So in order to bring Canada in there, they had to assist, because the Canadian Bill of Rights specifically was written in order to stop the communism, because there was quite a bit of fear and trepidation about the communists entering Canada, taking over Canada, as they had done in several other countries. And that's why it was there. So it's a blocker. It's a communist blocker. Like the way it's written, it's very well articulated and laid out in terms of recognizing. So you can't take them away because they're not given by the government. Whereas the charter, right out of the gate, I'm going to actually read it. Just to get it actually perfectly. Okay, no, that's not it. Sorry, it's taking so long. Oh, here it is, I think. Yeah, here we go. Okay. Right out of the gate, just a minute. It's not giving me the full. Oh, here. Okay. Okay. So, okay, so it does have royal assent, or no, sorry, no, I'm looking at the wrong one. The 1987 Constitution Act has royal assent. Sorry, gave me the wrong document. I pressed the charter, but the charter didn't come up. Okay, let me try again. I'm going to have to just... okay. Okay, finally. This is what I wanted to read. Right out of the gate, it says that you have a guarantee of rights and freedoms. It doesn't say human rights. And that's not a mistake. Human rights are natural. They're God-given, inalienable. Rights don't have to be that. And in the case of the Charter, it is not. The rights are what the government gives you. And right out of the gate, Section 1 says, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Now that sounds very grand, and it sounds like, it's really, they've got our back there. No, they got their own back there, because Section 1 allows them to override your rights if they think they have a good enough reason to override your rights. Well, that negates the whole concept of having rights. The rights are to protect you from the government overreaching, overstepping, abusing their power, etc. So why would we agree or want the government to decide if they have a good enough reason to override your rights? It doesn't even make any sense. It's like the hen being in charge of, the fox being in charge of the hen house. It's not protective, and it's not supportive. And the problem being, they can go ahead and make the legal changes that violate your rights, such as they've done with the COVID measures, and then it's up to us to file a constitutional challenge to bring those rights back, or to reassert them, if we even can, because that's a tall order. Because what you have to do there is you have to initiate, which is fairly complicated. The whole process, initiating, it's not so much, but the whole process is quite complicated. What you have to do to make your case, and in the case of COVID, you're going to have to make the case that the science is no good, and that their decisions were not reasonable because the science didn't support them to support that, because by initiating the charter, you are agreeing that that there can be good enough reasons to override your rights. But in the case that you're raising, you're saying, but in this case, it isn't. So you're actually also accepting the jurisdiction of the court to have enough power to adjudicate this. And they have, in fact, done that. I'm going to read that as well. Section 24 in the charter, which is here. This is what you have to do to invoke the charter. And I'll tell you what's wrong with that in a nutshell. It's 24.1. Anyone whose rights or freedoms as guaranteed by the charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Well, again, that sounds very nice, very noble, but it's not. Because, like I say, you're going to the court and you're saying to the court, in a way, there's an implied acceptance that there can be some cases where, it's justified, demonstratively justified. But in this case, we're claiming that it's not. So we want the judge, so we're giving the judge the jurisdiction to go eeny, meeny, miny, mo. And reason being is that they're not, like if you read that statement or listen to that statement, the court of a competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Meaning the judge now has discretion. He's not confined by common law. He's not confined by law itself, because it's what the court, and the court means the judge, by the way. So this also excludes a jury right out of the gate. So you're not getting a jury. And that's ridiculous, preposterous, in fact, because a judge cannot adjudicate issues of rights impartially, because they're appointed by the government and their salary is paid by the government. So they're not impartial. They're biased. And no jury. So a jury would do better. And the original common law was based on jury, and we kind of shoved them off. Like there's no point in time where we say officially that you can't have juries, but we've kind of made practices and policies only, not law, that it's this kind of situation where we want juries. And currently it's for criminal cases where they're seeking more than 5 years incarceration. But we need juries for all cases where we're claiming that the government is overriding our rights. And in this any case connected to COVID, that's exactly what the concern is. So that's not the way to go. In the Bill of Rights, you don't have to invoke it. You just have to cite it. So I can give a good example of how a person can be completely autonomous and exercise the rights there. Let's say that you got a ticket for protesting in a group over 25, just saying, or a criminal charge for, they call it common nuisance. So they give you paperwork that is making a claim against you. We'll just confine to the tickets because it's easier to relate it as a claim. Criminal is also a claim, it's a little more mucky. But the bylaw ticket, let's say $1,000 bylaw ticket for being in a, actually I think they were $880 because they call it the 880 Club, the people that got those tickets. So $880 for being in a protest of persons over 25. Say if you're completely 100% sovereign, you've even done all, some ritualistic stuff that goes on, and you've never consented, and you're making a public statement to that effect, and so on. So you get this claim that you owe them $880 because you've transgressed in some way. So some people say, oh, all the system's all corrupt, just rescind, just straight on there, rescind, don't engage with them, don't contract with them, just forget it. Like, we're going to make our own system, that's better. We're just going to withdraw from that system. And no, I don't agree with that. I think that we should come forward and say, okay, you have made this claim against me that I've done something, to violate other people, because that's what claims are supposed to be about. That you've done something to harm others, or the public in general, or people specifically. So with this claim, you can say, I don't think so, because you have a responsibility to me that you've made in the Canadian Bill of Rights to respect my fundamental human rights and freedoms. Well, I have a fundamental right to freedom of speech, association, and assembly. So by giving me this ticket, you are interfering with me. So in fact, I have a claim against you. And that's as simple as that. I don't have to pay taxes. I don't have, and again, I'm not advocating any of that. That's all personal, individual decisions. And I don't believe in creating big armies of people trying to do something by force because it's big, I think that we should all live independently and make decisions and take responsibility as individuals and try, and when we have like collective agreements with each other, they should be reasonable and cover everybody equally, stuff like that. But it's up to us to do that. And anywhere that it pops up that it's not, we should be going, got to be changed. So anyway, that's what I'm advocating. Same with the schools. Now, the schools have, in many cases, become unsafe. So I'm not saying leave the children in school in an unsafe situation. But I don't believe that it will be effective at the end of the day if everybody just says, oh, that's it. No more school for our kids. They're homeschool. We have nothing to do with that. Don't talk to us about that. We're not going to, do anything. Just withdraw and start our own independent self or homeschooling. And again, I'm not trying to say people shouldn't homeschool. I see many cases where the kids are well looked after and happy and so on. But other people, including myself, like the idea of having a community response to that education. And I'm not one to accept poor conditions just because that's what they're doing. I'm all about making sure that it's safe, reasonable, class sizes. I've fought, for my kids. My kids are all grown and whatever. But I've taken my kids out of school because of the conditions in school. And I was able to get change, just me, myself, and I. Like not some big group or whatever. And the way I did it was I took them out and I identified in writing why I was taking them out, and then started pushing and bitching and complaining everywhere I could think of that I want my child back in school. So this needs to change and this needs to change and this, because school is supposed to support their emotional, social, and physical development, and the things that were happening were contrary to that, so they need to change. Something needs to happen. And I did that in Alberta with success. And I won't go into detail with that today. Maybe I'll do another video about it later. And I did that in Ontario with success. So the idea is not to just like leave, and say, like, I'm taking my child and I'm going to bring them home where it's safe. You can do an intermediate thing, which is bring them home while they're safe and scream for the changes that need to happen. And you don't have to, I'm not trying to push people to take this position either. If you just want homeschool because you don't want that structured, and I don't like overstructured either. I think that the classroom should, at least till grade 6, should be activity based, and so they have a lot of interaction and they're learning through their play and all that kind of stuff. So I'm not into the sit in rows and be quiet and whatever. But these are these changes we can demand. It's our school. We're paying for it. Why should we have to run away and pay again for another homeschooling situation. Now, if you want to, that's fine. And I'm not ever going to lobby against or complain. Like, I'm not going to be the one, saying you should make them, bring them back to school and force them to go to school. No, no, no. If they don't want to go, that's fine too. And what happened, just briefly, what happened the 2 times that I took her out, they came to me shortly after and flexed that muscle of that child needs to be in school, or you need to prove to us that you're doing a proper homeschooling and that you're qualified, blah, blah, blah. And I said, I'm not qualified, and I'm not doing a homeschool program. I'm doing the best I can to teach her like randomly what I can, but I'm not a teacher. I'm not trained. I don't know your curriculum, and I don't want to. I don't want her to be at home. I want her to be in school. So if you want to come after me, let's have it out. Why I'm at home. And now they're used to intimidating parents that are just saying, no, I'm withdrawing from the school and I'm staying at home. That's the game they play. That whole, whatever, school is necessity and the parents denying it. So jump through this hoop, jump through that hoop to prove to us and all that. But it didn't work for me because I was like, well, bring it on. Let's have that. So they're like, ooh, okay, that's not going to work. So then they started to resolve. And they did that both in Alberta, in Calgary, and in Ottawa. They did that. And one was in grade, let me see what grade it was in, about grade 3. And the other one was in grade 7. And it worked both times. And again, it's for another day. So back to the can you be sovereign and use the Canadian Bill of Rights? Absolutely. You can be 100% sovereign. And when they're making a claim on you, you can go and you can even raise a claim against them without losing your sovereignty. Because if they're infringing or encroaching or whatever, violating, you can go and hold that document and say, hey, I'm a human person. This applies to all human persons, and I'm a human person, and you're doing this to me. So if you look at it more in a historic sense, like say before our government got so big and bureaucratic and nonsensical, we would make agreements with each other, not necessarily even write them down, but you don't do this and I won't do this, or I'll do this like this and you do this like this. And when those agreements are made, it's appropriate and healthy to go and to say to the person, hey, you're breaching this agreement. You said you wouldn't do it, now you're doing it. Same thing here. This is an agreement. This is all it is, simply is an agreement that's written up and signed broadly, because all the MPs signed, or not all, but a majority of the MPs in the day, 1960, representing all the rest of Canadians, agreed to bring this into law. And I mean, that's a bone of contention that really nobody is asked if they want to be part of the system. But the majority of people accept to be part of the system anyways, even though they're not asked. But if you're not asked and you're not want to be part of it, it still applies to you. It still applies to you because it's a commitment to all human persons in Canada. So you can still pick it up as an autonomous person, and it just as you did in the old days, like where everybody was autonomous and you had agreements, you could go and say, hey, you have this agreement towards me and you're not keeping it. So the same as this. That's as simple as, I mean, things have become so complicated, multi-layers and bureaucratic and so on, but really it's just an agreement between human beings, and is meant, and specifically this Canadian Bill of Rights is meant to be something that helps facilitate peaceful living. And in particular, they want to, well, they're doing 2 things. They're protecting you from overstep and overreach by your own government, but it's also assisting, and right now as we speak, it's assisting us in protecting our system from the invasion, the communist invasion. And you can see that it is having an effect, positive effect, because what they intended to do for Canada with those bylaws was to put us into martial law. We never went in martial law. And we have protections on the federal level. They can't just willy-nilly bring in the military against you. They can't bring it, never mind, like willy-nilly. They can't bring it in, period. If you look at the Emergency Act, I'm going to bring it up, and I'm going to read you a wonderful section in the preamble for those people that are afraid that the next phase of this is the military being rolled out against us. Okay, this is Emergency Act 1985, which replaced the War Measures Act, okay? War Measures Act, they could have brought out martial law against people. In fact, Pierre Elliott Trudeau did do that in 1970. He violated our rights in a process of supposedly dealing with the FLQ, which was a terrorist group in Quebec. But after he left in 84. In 85, they brought up this Emergency Act. And in my view, it was the politicians back in the day, maybe even pressured by the people, wanted to slam the door to anybody subsequently jumping in and making martial law and all the havoc that creates. Like he passed all kinds of legislation, 2,000 bills in closure over 16 years with authority that he wiggled out of the the War Measures Act, because he changed it into the Emergency Measures Act, and then changed it also that the Premier or Prime Minister rather could to invoke it. So he kept saying, "Oh, the economy's emergency, the oil price is emergency," and God knows what else. But he kept on continuously invoking it and passing all kinds of unrelated laws to whatever the emergency was. He passed metric by an order in council. No discussion, no debate, nothing. Just boom, there's your law. Read it and weep. And he made CSIS. He brought CSIS in like that. He made changes to first-class mail, privacy of first-class mail, and wiretapping. And I don't know all the other ones, but those ones can be checked to confirm what I'm saying if somebody wants to look into it. Look in the Hansards, and you won't see any evolution of those changes. They just came in through an order of council, boom, bang. And that's not even, under normal circumstances, it's not legal. Under those old emergency provisions, it was legal. Now, it's not. If it violates your rights, it's not legal. So here's what it says. In the preamble of the Emergency Act, 1985, says, the governor in council, in taking such special temporary measures, would be subject to the Canadian Charter of Rights and Freedoms and the Canadian Bill of Rights. So this is after the Charter. So that's another thing people go around saying, that the Charter superseded the bill. Well, why would it be adhered to in a bill 1985 after the Charter? And must have regard to the International Covenant on Civil and Political Rights, which is a real powerhouse. Protects you even specifically from violations of your rights during an emergency. It even articulates it. So does this, particularly with respect to those fundamental rights that are not to be limited or abridged even in a national emergency. So no martial law to deal with an emergency. So that's, you can look that up. It's very reassuring and very, and unrelated, but I just want to throw it in again because I hear it so many times I want to throw up, that Saskatchewan is in a state of martial law. And that is so preposterous, it's not even funny. So anybody that's so-called leaders that are telling you that, like, not a good idea to be following them. First of all, they're claiming that it was September 13th that the Saskatchewan government passed law to bring in martial law. But meanwhile, what happened was that they declared a state of emergency on September 13th. And in that statement that they put out, that's on the website, underneath where they're saying that they're declaring a state of emergency, they're quoting the emergency Emergency Planning Act, Saskatchewan Emergency Planning Act, and it's not a new act. It's 1989. I think there was changes made later, but not related to this. And that part is an old part, and it's a quote, unquote, out of that act, and what it is the powers of the minister under a state of emergency. So when you read that in its full context, it doesn't mean that these are the things that the Saskatchewan government is going to do right now. This is what the Saskatchewan government can do if they need to do it. So it has things like evacuate your property, possess your property, and those would be in relation to whatever the emergency was, and it would have to be relevant to whatever the emergency was. So if, for example, tornado went through and the buildings are all crashed, you don't want the police to have to get a warrant to go in and see if there's bodies trapped under the rubble, okay? If the cows have mad cow disease, you don't want them to have to go get a court order to, to get to round up the cows and kill them and get them out of the community. Or whatever. I mean, that's just off the top of my head. But if you read it in the broader context, there's really, I'm not really even thrilled that they do have that much power under an emergency, but regardless. And on top of, Saskatchewan government cannot bring in military. And that's what they're saying. They're martial law, and they're going to bring in the military and do all these things to you. No, they can't, because only the federal government can bring in the military. They can ask the federal government, but if the federal government was going to do it in response to an emergency, they'd have to call a state of emergency, and then they could send military, but not to override your rights, to assist. Like they assisted in the ice storm, for example, and they can assist in large fires or whatever where there's not enough hands on deck to deal with the crisis. Military can come in to assist. But in Canada, they cannot come in to override your rights. Nada. We have a really good protective process going on there. And they're having to work overtime trying to get around it and deke it and get people sucked into it. They're giving loans and grants to companies and getting them to agree to do public health guidelines and to be able to come in and check and see if they've adhered to the guidelines, because public health doesn't even have the right to enter. And so they're having to jump through hoops to try and get at us and to really undermine our rights and destroy our rights. But they haven't. They're still there, and they're flying. Now, stay away from the charter, because that's like a quagmire, because time-consuming, very expensive, and the remedies are down the road, so you get charged with something, the POA especially. Criminal, not so much, because I think you can bring the charter in as part of your defense in the criminal. But for the provincial offenses or for the closures, business closures that are happening from the city, they won't let you use the charter to present your case or defend your case. You can file something, but it's down the road, and in the meantime, you can't function. Your business is closed, and how long are you going to be able to keep that going if you don't have revenue coming in? So it's not the way to go. The Bill of Rights, you can use it for the closures, you can use it for tickets, you can use it for in Ontario and for criminal charges, and you can even use it to refuse to do, say if you're a business, you can refuse to do the vax passport the way they're wanting you to do it, because the way they're wanting you to do it is violating the criminal code, and it's violating the Canadian Bill of Rights. And I'll just state that quickly. The way it violates the Canadian Bill of Rights is Section 1, which is life, liberty, and security of person, which includes your right to privacy and your right to bodily integrity. Security of person is bodily integrity, and that incorporates the right to freedom of choice with medical treatment. And then Section 1 B says you have a right to be treated equally by the law and to be protected equally by the law. So they're treating a vax person like this and an unvax person like that. And the criminal code, say if it's an employer saying that you have to give your vax status or you're fired, and if you haven't had a vax, you're fired. That is using threats to make you to allow them to violate your freedom of privacy or your right to privacy, and it's coercing you to have a vaccination. So it's using intimidation and threats to make you have a vaccination. So that's extortion. And whether it happens or not, it's still a criminal offense. Like if you refuse, it's not like, well, no crime got committed. Yes, it's attempted. And the same, it's in a vaccination where there's no consent. If you're being even pushed by your authorities, that's considered no consent after. So that's an assault. And there's liability, ample, tons of liabilities. There's liability for breach of privacy and for the breach of informed consent, and the criminal code violations, which include uttering threats, extortion, and assault. And the last one is inciting hatred, because this is in fact what they're doing. They're isolating, they're ostracizing and punishing people for. My dog's going crazy. There's a neighbor there. So this is what they can do. They can say, okay, you want me to enforce this vax passport? This is how I'll do it. The person coming in, you say to them, I'm going to ask you a question, and you don't have to answer. If you don't want to even hear it, you can go ahead in. Like say if it's a gym, like go ahead in the gym. And if you do choose to answer, whatever the answer is, you will not be refused service. So then you can go on to say, do you have a vax passport? Whatever their answer is, go ahead in. And if the answer is like straight up no, I don't have it and I'm not getting, go ahead in. Then if you do it like this, you're not violating all these laws. So they really are not going to get anywhere at the end of the day. They can't say you refuse to do it because you're doing it. And so they can't use all their muscle around that. And if they try to say, well, you're not doing it properly, what are they talking about? You're not breaking the law? They're not. That won't work in court. So you're good to go. Or you could do as one of my associates has done. His name is Kelly Hale. He's got a pub in Kingston called Jack's Tuesday Pub. And he's straight up said, I'm not doing it. It's violating the law, so I'm not doing it. And they're hitting him, but he's fighting back. So they've, right out of the gate, they've given him fines, like POA fines. And they gave him, they removed his liquor license. But interestingly enough, I want to mention that Public Health made a statement in his paperwork that they were called with a complaint that he wasn't enforcing masks and he wasn't enforcing the passport, the vax passport. And they said, but because it's a voluntary program and we've spoke to him and he says he's not doing it, we're closing the case. So what is the bylaw enforcing if public health is saying no problemo? It's all combuberated, and it's because they're having to try and deke and like try to get around stuff and try to get this done without or in spite of the fact that we have such well-developed law and protection. For example, employees have protection under the Occupational Health and Safety Standard Act. And with regard to health workers, they're supposed to be subject to, Directive 6 coming out of Public Health, made under the Health Promotion and Protection Act. And when you read the Health Promotion and Protection Act, it says that if there's a conflict between that act and OSHA, OSHA prevails. So then if you look at OSHA, OSHA says that the employer cannot require the employee to give medical information unless there's a court order, unless there's a tribunal decision, or a statute. And there's no statute. It's all regulation, which initiates rinky-dinky bylaws. That's all there is. And in the case of Directive 6, it's not even a regulation. It's a directive coming out of public health. So we're really, really good. And I think we have, he has a good argument with regard to his liquor license, because they're taking it before he's even convicted. So, and they're taking it for reasons that are unrelated to their jurisdiction. Like, he's not breaking their rules. So, it would be the same as, oh, you got a speeding ticket, you lose your liquor license. Huh? And they can't say, well, by taking the license away, it makes it safer, because it doesn't make it safer, because the same number of people are in there. They're just not drinking alcohol. And then my student and I were talking about the case last week, and we came to that concept, and then we thought, wait a minute, alcohol kills the virus because they're making you put it on your hands, supposedly to kill it. So when you drink it, it must have the same effect if there's any virus in your mouth or in your system when it comes in contact. So I looked on the internet to see if anybody, did any discussion on that. And sure enough, there was an article in there that was endorsed by the World Health Organization, and it says, without any reference to anything to support it, it just says, absolutely not. It will not kill virus in your mouth or in your body, only on your hands. Ridiculous. So anyways, we're not going to even use that argument. We've got other arguments. We might mention that in passing, but we have other more substantial arguments we're going to use. They cannot force somebody to break the law, and that's what, in fact, they would be doing: break these criminal provisions and this community, or the Canadian Bill of Rights. And I'm going to end off here just with one last, the reason why the Canadian Bill of Rights applies is because when the company is undertaking to do the Vax passport, they're enforcing law. So if they're enforcing law, they're covered by the criminal code, their activity and the way they're doing it. And they're not allowed to ask. They're asking for ID too, which is another. Law enforcement is not allowed to demand ID unless there's proof, reasonable and probable cause to believe that you committed a crime. Then they can ask you for your ID, or if you've violated the Highway Traffic Act, and that's it. So a 16-year-old in McDonald's at the door does not have the authority to ask for your ID and your Vax passport. That's, and no one does. But I mean, on top of that, my friend went into McDonald's and literally a 16-year-old said, "Where's your ID?" Like, and anyways, this I don't think is going to last that long. I think they've got a deadline for the ROA, which is January 1st. And I think everything might, it depends on how much compliance. That's what they're trying to do. They're trying to just rope as many people into it, to complying. Like employees think, oh, I can't lose my job. Okay, I'll have Vax. Like they're trying to, or people, oh, I have to go to my gym. I'll have to get a Vax. Things like that. So they're getting a lot more people Vax that didn't want the Vax. But that's going to bite them in the ass too, depending on the circumstances. And if there's any injuries, Vax injuries, that's going to bite them in the ass. Now, they do have, I know I said one more, but there's two more. There's a piece of legislation they passed that said anybody that's enforcing the COVID measures is removed from liability, as long as they do it in good faith, and even if it's unreasonable what they're doing. So they know it's unreasonable. They put that in there to protect themselves. But this notice of liability, especially the one that we've created, it's progressive. You start a collection process and really start to get some leverage to fight back. In that process, you're showing them, you're telling them exactly where they're violating your rights. and they have no excuse after. They can't say, oh, didn't know. I just was following the public health said to do that. I mean, I didn't know. Well, yeah, you knew because we sent you notice of liability and spelt it all out and put hyperlinks so you could check everything we're saying. And at the end of the day, they're not going to be able to play dumb. And don't forget the Nuremberg trial. Nazis that did the atrocities in Germany under Hitler tried to use the argument, well, they told us to do these things. They ordered us to do these things. And the Nuremberg panel, no, it's not acceptable. So it's not acceptable for somebody to say, oh, well, they told me to demand that we can violate your privacy and use threats on you and blah, 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 blah. It's not going to be a defense at the end of the day. So I'll leave you with that. Fully sovereign people can use the Canadian Bill of Rights. You don't have to give up any freedom or any decision-making or anything, and you can still say, hey, you guys made this commitment to me, including the Queen, by the way. It's got royal assent, so the Queen is also obligated to protect, and it's well articulated. And if anybody has any capacity to get some of the old case law that established these rights along the way, life, liberty, security, person, all that, they're quite old, so they're not in our databases. So, but if anybody has them or knows where they can be located, I know they might have some at the university libraries. They're quite large, but I haven't been in there. I don't know. They're doing the Vax Pass thing, so I don't even know if I can get access to it. And I'm not sure what they're doing at the courthouse. They also have a reasonably good one there, but it doesn't go back very far. But the university ones do. They go way back. So if anybody has any of this old case law, we have one from 1938 that was developed regarding the Alberta government, social credit government, was having a problem with the press. The press didn't like them, and they wanted to stop them. Like the government wanted to stop the media from criticizing them, so they passed a piece of legislation that prohibited them from doing so. And that was challenged, went up to the Supreme Court, and the Supreme Court said that the rights are violated, freedom of speech and the press are violated, and they overturned the law. And they further said that they recognize that Canada has an implied Bill of Rights, so that's even before the 1960 Canadian Bill of Rights. That was 38. And their final conclusion was that the province cannot violate your fundamental rights. So even though the Bill of Rights doesn't apply to the province, case law applies to the province. As well, the Canadian Bill of Rights does apply to all law enforcement. So we can't overturn these regulations with the Canadian Bill of Rights, but we can with the case law. But we can stop police, bylaw, public health, whoever, from violating our rights because it's law enforcement. So it's pretty good. And if you live in Alberta, so jealous, because they have an Alberta Bill of Rights that would actually allow you to protect from the enforcement the way we have here, but also you can overturn those regulations, because it actually says in your Emergency Act that in their emergency planning they can't violate the Alberta Bill of Rights. So if anybody is watching this from Alberta, you might want to get on that. Okay, that's it for the day.